Sa panahon ng mabilis na impormasyon at kaliwat kanang balita, kailangan mo ng isang channel na mapagkakatiwalaan, diretsyo at para sa bayan. Ito ang Balitang Pambansa, ang iyong bagong tahanan ng mainit na issue, tunay na impormasyon at mga balitang hindi mo dapat palampasin. Mula sa mga trending na kaganapan sa social media hanggang sa mga seryosong isyong pambansa. Bantay kami sa bawat sulok ng bansa para sa iyo. Hindi lang basta chismis, kundi validated news, mga impormasyon na may batayan at mga kwento ng tunay na buhay Pilipino. At kung gusto mong laging nauuna sa kaalaman, huwag kalimutang mag-like, mag-share at higit sa lahat, mag-subscribe. Dahil sa Balitang Pambansa, balita mo, boses mo, bayan natin
Game.
Distinguished gentleman from Tarlac favor me with a few questions. I will be gladly accepting his favor. And if the Senate President will allow me, after a few questions, I will make my own manifestation to that effect.
The gentleman may proceed. Should Senator Marcoleta so allow it?
Yes, Mr. President. Thank you, Your Honor. Thank you very much, Mr. President. Thank you. So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR or the motion for reconsideration filed last Monday by the House of Representatives. Is it not, Your Honor?
The question whether is it
Yes, your
subject
basis
to
for your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor, that's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final, thus appealable. Ngayon, naka-appeal na. Marami nagtatanong, kung naka-appeal na, ba't tayo nagmamadali? I-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes, yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo po, palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn eh. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo, meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babaligtarin po nila yung kanyang sarili. Kaya, napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President.
Nako,
And,
ano yung research yan?
To remind everyone,
Sa mo rin research siya? Sa school bukol?
the reversal of the Supreme Court's own decision is not impossible,
Oh,
even in landmark cases.
oh.
In the case of Labugal, Bilaan Tribal Association Incorporated versus Victor Ramos GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR, reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lily Lopez versus Lolito Lopez with GR numbers 25497-957-58. So, may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi nyo, unanimous decisions po ba lahat?
I am not sure about that.
Nakayari tayo dyan.
But one thing,
Yan ang problema. Magsasite ka ng ruling. Magsasabi-sabi ka ng ganyan. Hindi ka naman pala sigurado. Baka ginugudtay mo lang kami, ha? Soto, ha? Problema sa'yo, eh. Yung mga researcher mong taga-school bukol siguro nakahanap ng mga yan.
I can say is that if there is a mistake, unanimous decision could become a unanimous mistake.
Wala pa pong nangyari gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Nako, yari ka dyan. Yari ka dyan, Soto. Kung hindi mo madadaan sa pagiging veteran. Nakanantawa, galing talaga nitong si Senator Rodante Marcoleta. Pag ako'y nananakbo sa daan at nakasapatos, kaya hindi ako matitinik. Nako,
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure.
Natatawa na lang si Senator Rodante Marcoleta. Anak ng toko, paano mo naging senador to? Namuti na lang ang buhok sa Senado, hindi pa niya alam kung ano kayo mga pinagsasabi.
Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ang kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-tahasang hukuman na gumawa ng paraan para isang tabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Nako.
Thank you, Mr. President.
yan ang testamento na hindi porket veterano ka, magaling ka na.
Your Honor, thank you.
Lagi naman meron talagang first time. First time na ilang paso ng first timer na senador. First time. No, Soto? Laging merong first time. Isang veteranong senador na muti na lang ang buhok dyan sa Senado na ilalampaso siya ng neophyte na senador. First time.
But as I said earlier, not because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question, but then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Canal Rock has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation with your permission.
Akala mo galing talaga, no? Pero ang lahat to ng tanong na yan, ginawa lang ho niya ng kanyang chief of staff ng mga abogado niya. Pero si Senator Rodante, walang abogado. Ako ang abogado.
Mr. President, for the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with the sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress.
Grabe, ang dami ho nila dyan sa minority, no? Si Soto lang ang nagkaroon ng lakas ng loob na makipagtagisan kay Senator Rodante Marcoleta. Si Bamakino, si Risa Hontiveros, si Kiko Pangilinan, hindi talaga ho sila tatayo. Isinubo ho nila sa napakahusay na Rodante Marcoleta itong siskol bukol. Kung sino pang hindi abogado, siya pa ang sinubo nila sa napakahusay na abogado. Magaling din naman. Hindi nadadaan niya sa paputian ng buhok, Brad.
Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Now, sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. The treaties, bills, resolutions, anything filed continues. It is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus.
Nako, wag kang babanat ng ganyan. Kung di ka abogado, masosoplak ka na naman yan.
Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nila palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mamali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress.
Ang ginagawa mo dyan, ba't di ka pumunta dyan? Talagang ang dami yung falsifikado sa sinasabi nitong si Itbulaga. Yung mga kasabihan niya, talagang ibang klase yung mga kababayan. Pati yung mga show sa Itbulaga, yung mga kasabihan. Hanggang sa Senado, dinala...
This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan.
Nako, yan na naman.
Now,
Bulaga na
to continue, Mr. President, and this is very much related. The Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This 3rd and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the 3rd mode, which is the fastest way, was provided in the Constitution. Why did they ask? Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsud, Atscuda, Sarmiento. So, Mr. President, Continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun eh. I've read that the basis for the retroactive application of the...
Malaki ang problema itong mga pinagsasabi nito dito ni Soto, no? Kine-question nga yung ilinabas na desisyon ng Korte Suprema, anak ng toko. Meron ng problema dito mga kababayan. Ngayon, kung hindi kikilos ang Korte Suprema sa paglalabas ng mga ganitong klaseng komento noong mga senador, mga abogado o kung sino-sino mang kini-question ang kahusayan ng mga maestrado ng Korte Suprema, malaking problema ho talaga ito. Senator, hindi po nagsasalita si Sendanje, pinapabayaan niya na pinagbibigyan niya itong si school bukol.
New definitions because the Senate now has not acquired jurisdiction yet. Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court?
Pinagpilitan nga. Kaya nga sinuuli. Kanina alam mo sinuuli. Ngayon, hindi mo na naman alam. Kaya nga ibinalik, di ba? O ngayon na naman, nag-constitute sila pero ibinalik sa House of Representatives. Maraming katanungan. Una sa lahat, talaga nga bang hindi nyo linabag yung one-year bar rule? Kung hindi, okay, pagpalagay na natin. Kayo nang masunod. Sa tingin nyo hubad, pagka mag-uumpisa ang trial, hindi rin pag-uusapan yung mga issue na yan? Kaso pagka pinag-usapan, paano ba natin pinag-uusapan to? In the first place pala, wala tayong jurisdiction kasi mayroong problema, mayroong linabag noong isinasampa pa lang yung mga impeachment complete na yan laban dito kay BP Sara. Kaya pumagitna na ang Korte Suprema para magkaroon na ng kaliwanagan dyan sa issue na yan. Kaso pinagpipilitan nyo. Anak man to, problema tayo.
Nag-rogue pa kayo. You even sent out summons. Ano yun? June 9, the Senate President took his oath. June 10, nag-convene ang impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense. Ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, but several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off topic, sabi nila. Para bang pinagtagpi-tagpi, basahin nyo mabuti. Uli, ang daming gagaling ng mga abogado rito, basahin nyo. It even quoted the entire Article 11 of the Constitution, not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this...
Kung obserbasyon na lang ng isang abogado at ng isang school bukol, magitbulaga ka na lang. Kung yung mga obserbasyon mo na lang ang pakikinggan namin, wag na lang. Kaya ka lang naman nandito dahil tinatanong mo si Senator Rodante Marcoleta. Ba't ayaw mo siyang pasagutin? Ang haba-haba ng pagsasalita mo, sa kanya pa ang floor, akala mo sa'yo ang floor.
President impeachment case
Sa floor, eh.
is of no moment to me. The Vice President is a friend of mine. The
Kabalbalan, sinungaling. Kaibigan daw niya si VP Sara. Eto sa'yo, walang yaka.
the former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out
Kaibigan.
is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leoded himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly have the right to call attention to the fallibility of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwede
Kailangan ma-deliver ko to ng maayos. Yung pagkakasunod-sunod, dapat tama to. Wala pang tulog yan, kaka-practice niya kagabi.
mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, it is a unanimous mistake. That again can be corrected by setting aside and reversing prior pronouncements. Again, they have filed, the HRP has, the Office of the Solicitor General has filed the MR last Monday. So, in this regard, we shall wait for the resolution of the MR. Please, let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors. For their sake and for the
Ano ka ng tokwa? Blatant error! Galing kay school bukol na nagkamali ang Korte Suprema doon sa ilinabas nilang desisyon na ideklarang unconstitutional yung impeachment nitong si Vice President Sara Duterte. Sa kadahilan ng linabag ng House of Representatives, nagsusumigaw na ang mga ebidensya ilinatag ni Senator Rodante Marcoleta na meron talagang ginawang paglabag ang House of Representatives. Ngayon nagkamali pa ang Korte Suprema ng TOA. Kung ganito lukuhan na lang sa Pilipinas. Pagka ito pinagbigyan ng Korte Suprema, malaki ang problema natin dito. Nagpasailalim ho silang lahat sa impluensya ni Martin Romualdez kung sakali na mangyari ang kagustuhan ng mga school bukol na kagaya nitong si Tito Sotto, di ba?
sake of future proceedings, let us not dismiss forthwith. And in that light, considering the motion of the gentleman to motion to dismiss, I move to table the motion to dismiss. A motion to table has a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, may I have a quick reaction to the manifestation of the gentleman?
The gentleman may do so if he so desires.
Mr. President, in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints prior to the fourth one were dismissed because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional. There was no referral to any committee. Ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag kami 1/3 na or more, ay pwede na nilang huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh. So hindi na po kailangan na i-distinguish pa natin yung adjournment and sine die adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ang Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, ang kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress, where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Sotto, and first movant of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our, and remind, Mr. President, our colleagues of our concurrence during our caucus held last week, that we will debate on this and talk about this and discuss this matter, Mr. President. But if the minority leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the minority leader, considering that it takes precedence, Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the chair that during our all-member caucus, which the chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this was the date certain that was agreed upon in caucus. Maybe hear from the distinguished minority floor leader if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR filed. There was no mission.
Palusot yan. Wala, hindi talaga gentleman tong mama na to. Hindi marunong sumunod sa usapan.
Motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes...
Pero anticipated nyo na. Noong nag-uusap kayo, alam nyo na magpa-file ng MR ang House of Representatives. At sinabi na nila na magpa-file sila ng MR. Nako.
It's a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as what? As a Senate or as impeachment court? I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules, and you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President. Thank you.
We note the intent of the distinguished minority floor leader, but the chair would therefore like to make some points known before we act on the motion.
Mr.
What is the
President?
pleasure of the majority
Yes,
floor leader?
Mr. President, upon conferment with the minority leader, Mr. President, he is amenable, Mr. President, for us to continue with the discussions and debate on this particular topic, Mr. President. And so with that, Mr. President, may I move that we recognize the distinguished gentleman from Cavite, Senator Panfilo Ping Lacson,
Ito, si Lacson
to
naman sa sala.
ask his questions, Mr. President.
Well, first, Chair would like to thank the
Thank you,
magnanimity
Mr. President.
of the distinguished minority floor leader in order for us to be able to continue with the debates. The gentleman from Cavite, Senator Lacson, is recognized for his interjections with leave, of course, of the gentleman who has the floor, Senator Marcoleta. You may proceed, sir, if Senator Marcoleta so desires.
Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed then.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this august chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss, as submitted by the honorable gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer a space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin. Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable Marcoleta? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with us good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session, given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. To answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished minority floor leader himself, acting as majority leader.